President Bola Tinubu has applauded the judgment of Judge Robin Knowles of the Business and Property Court in London for awarding a landmark victory to the federal government of Nigeria over a firm known as Process and Industry Development P&ID Limited. Judge Knowles dismissed the $11.5 billion value of the award and accumulated interest previously won by P&ID over a failed 2010 deal to allegedly build a gas processing plant on the grounds that the award was obtained by fraud. President Tinubu commended the UK court for prioritizing the merits of the case above all other considerations. Well, joining us in the studio is UK-based solicitor and publisher of Village News, Olufemi Aino. Good morning. Thank you for joining us.
Yes, good morning.
Welcome.
Thank you for having me.
Well, there are those who have said, hallelujah, sang hallelujah. Finally, Nigeria succeeded in winning this case after the long battle in court. But let's get your perspective to how we arrived here and what your reaction is to this victory.
Well, the point is that this is a victory for the rule of law. It is a victory for the Nigerian people, and it's a victory for the Nigerian nations. But the way forward, lessons have to be learned.
Absolutely.
And the million-dollar question, which demand an answer, how did we get into this mess, if I can call it a mess? And it's a mess indeed, considering the fact that some of the dramatists personnel, some of them, as we speak, we need to search their conscience, whether they serve this country very well.
Right.
And if you read the judgment, there's recommendations there where the judge said, nations, when they are drafting this sort of agreement, they need to get professionals involved and experts and make sure things are properly done.
Yes.
And one particular thing here is that, you see, the challenge was based on the fact that under the Arbitration Act, whether there was serious irregularity and whether the award is contrary to public policy. And during the arbitral award, the initial award, there was a statement by the chairman of the P&ID. It's late now. And he said they've already spent almost 40 million USD regarding this project. And at the end of the day, it was now discovered that nothing of such has happened. The land that was allocated to them in Cross River State, they did not even pay for the land. The presentation that was made in securing the contract belongs to General Danjuma. And nobody asked questions. And those who are supposed to ask questions, most especially, there's a gentleman called Mr. Tijani, was a former commissioner in Lagos State for mineral resources. He was the chairman of the technical committee. He expressed initial concern that I'm very concerned whether P&ID can easily execute this project because they don't have the experience, they don't have the finance, they don't have the resources. But at a point, if you read the judgment, he even admitted it too. What they did, they put $50,000 in a black bag and put that amount in his car boot. Then, at that point, he changed course. Subsequently, in his statement to EFCC, he even confirmed he received another $30,000 US. Not to talk of others. Some of them are facing criminal charges, as you know, like Mrs. Grace Tiger and the former Attorney General of Lagos State, irrespective Mr. Shashore himself. You see, so at a point, they now discover that, look, this thing, when you enter into any contract, fraud vitiates everything. You cannot go ahead and say, okay, I'm seeking damages. So when you know the initial intention, the whole scheme was a fraud from the beginning. And the most important thing, which Nigeria needs to do at this particular point, is that President Tinubu should set up a panel so that we investigate the people behind this mess. This is not the only case. There are others. There's one cautious Mahata, there's another one in America, and Nigeria stands to lose substantial amount of money if we lose all these cases. And there are some people we need to comment regarding this judgment. We must not play that. Number one, Abubakar Malami, the former Attorney General, irrespective of what people has to say, he took the bull by the horn to make sure we get to where we are today. Yes. Everybody is going on a rooftop, but nobody is acknowledging their effort. And the second person is Professor Yemi Oshibanjo, the former vice president. If you read the judgment, you will see the flood of correspondence between the vice president and the president. At a point, he made a recommendation that they should explore the possibility of settling the matter out of court. But at the same time, he attached a memorandum that he still has a concern that there is a fraud within this agreement. Then he made a recommendation to the president that there should be a proper investigation. The president now gave a directive, President Buhari himself, irrespective of what people has to say. In this case, at least he provided the necessary purposeful leadership. And we must commend that. He now made a recommendation that the EFCC should carry out a thorough investigation to get to the bottom of all this. Now,
this was under the
previous,
right, Ibrahim Magu.
Yes, under Ibrahim Magu. Now, there's another curious thing is that at a point, the Attorney General then, Malami, was even upset with Magu that they are not carrying out that investigation in a very punctilious manner. And then Magu wrote back and said that, look, we have carried out all the necessary. Then that investigation even unraveled a lot of things that people have been receiving money regarding this project. Now, how can you be a public officer? You are awarding contracts to people who are paying your medical expenses. And that is why Mrs. Tiger was actually charged to court. Yeah. And it's not limited to that. There are others who are receiving money behind. Look, even Mr. Shashore, who was retained, he did his best according to the judgment. Yes. Nobody is criticizing him for that. But there are some elements of his conduct that any reasonable person we need to ask questions about. Number one, as at the time he was retained to handle this case on behalf of the Federal Republic of Nigeria, he was a partner in a firm of solicitors called Ajumogobia and Okeke. And under the partnership law, partners owe a duty of good faith to each other. Any money you make, you must account. Now, he was retained by Nigeria for US and he was paid $2 million USD. But he didn't run the case through that firm. According to the senior partner, if you read the statement of the senior partner of the firm, that he kept the case from them and ran the case through another firm. That is a serious breach of partnership agreement.
Really?
And it is because
but it's not criminal in nature.
I don't know. Sorry?
But it's not criminal in nature.
I'm not saying it's criminal in nature.
I'm just
but
saying.
It's a breach. It's a breach of the duty of good faith. Right. We owe each other of a duty of a good faith as partner. And if you fail in that duty, it is a breach of the partnership agreement. Let's forget so the other partner can ask you to account for the money. Right. That is the way.
All right, Mr. Aino, so yes, you've raised another dimension to the possibility of Mr. Shashore's culpability, so to speak. But I just want to know what impact this verdict by Justice Knowles could have on the trial the senior advocate is having here in Nigeria, because it's tied to the P&ID, the fact that he allegedly paid $100,000 to NNPC staff, about 2 of them or thereabouts, but them now exonerating him, or this judge now exonerating him from any corrupt ties. And the judge was also said to have established that even Mr. Malami, the then AGF, could also see that he did not believe in the corruption allegation, because he went on to give this same individual another contract of magnanimous proportions 2 years after.
I take your point, but can I invite you to take my point? and that point is very simple.
Right.
Nobody is accusing Mr. Shashore of corruption.
But he's accused
in
the federal government.
Wait a minute. Right. If you read the judgment carefully, They are not saying he took money corruptly from NNPC. No. The charge at the Federal High Court is that Mr. Shashore, having received the $2 million as his legal fee, he paid Mrs. Ajelore $100,000. And that payment was made in 10 tranches of 10,000 each. There is another man called Mr. Ogune, who was a coordinator with NNPC. He also was paid 100,000. And Mr. Shashore, in his interview with the EFCC, actually confirmed making those payments. But his explanation was that it was a loan or it was a gift. Now, for a senior advocate of Nigeria, giving $100,000 as a gift, I think that is a bit over-generous, but that's a matter for another day. Right. And also, for a senior advocate of Nigeria, giving a loan of 100,000, we're not talking of 100,000 naira, please, for the sake of totality. 100,000 loan. Whether he has a license from the Central Bank of Nigeria to give loan, that is a matter. So the charge is facing at the Federal High Court is under the money laundering that you didn't go through the financial institution. That is the charge. And now, this judge has said, nobody has said that, no, he did not receive any bribe or anything, that he did his best in the circumstances. But whether that will help his case here of giving that cash out without going through the financial institution, because the case in court, there's a limit to which we can talk about it. Let's wait. If this is going to help him in a way in the criminal charge at the Federal High Court, because the judge made some comments that he did his best, this or that. But the first judgment said that that payment was actually paid to those individuals so that they can look away. And there's another thing which is very significant here, is that Mrs. Ajelore was very concerned about the way the case was being handled. So she actually was raising a memo to the senior personnel that, look, Mr. Shashore is not really fighting very hard, this and that. But after she received the 100,000, she started another discordant tune. You see, so these are the issues. But there's one significant point. I don't know, maybe I should just move there. Right. There's a lesson here. This is 140 pages judgment. Yes. The trial went on for 2 months, 8 weeks. 8 weeks, yeah. And the judgment was handed down. Nigeria needs to learn a lesson. And I hope the judges in Nigeria will read this. You see, if it's in Nigeria and they are going to deliver this judgment, all the lawyers will be there. Majority will probably be sleeping, because to read 140 pages is enough to take the whole day. And what normally happens in the UK is this. This judgment was given on Monday, okay? And I'm telling you this as a privilege, because I'm a solicitor there. Right. If you are one of the lawyers, you will have seen this judgment by Friday, because the judge will send it to you. That's the mail, via mail. Yeah, you are an officer of the court. Right. There are certain privileges you are supposed to enjoy. You understand me? And what they normally do is that when they send it to you, the clerk to the judge will ask you to go through. If you feel there is any factual error, you must email the clerk. And you copy the other lawyers too. And some of them, because don't forget, 8 weeks trial is not a joke. And while you are in that court, you are taking notes too, either for the parties, you are taking notes. So it may well be when you read it and there is a factual error that what Mrs. Adeyemi said is this and that. You can email the judge and the others can say yes, according to their note, so that the judge can, but you must not tell the clients that you have seen the judgment. Right. Yes, until it is handed down. And when a judgment is handed down, what that means in law, you don't need to turn up in court. Okay, so that is what it means. And what normally happens, the judge will come in court and they will say, this is my judgment regarding the case between the Federal Republic of Nigeria. The judgment is hereby handed down. Nobody is there, that's all. Or in the alternative, you can serve it by email. So this judgment, 140 pages, was served by email.
Yeah.
Can you imagine the lawyer sitting down and the judge reading through everything? But if it's in Nigeria, this judgment is going to be delivered.
But these are some of the issues that have been raised with regards to reforms.
Yes, and one of the senior advocates, and I think it's Okutepa or something, I can't recall the name, he actually said that, look, we need to try as much as possible to learn from this and make sure that, you see, cases in Nigeria get into unnecessary legal technicality. And they don't even, before they even get to the merit of the case, the momentum is gone.
Yes.
And even, look, let me tell you, your name is Veronica this. If I get your name wrong in my pleadings, in Nigeria, they can argue that from now to the end of the act. But in the UK, the judge can give it to you and say, why don't you just correct the name here? And then you do it so that you can get to the substantive issues. And in this case, what the judge did was really nice because it's a back-to-back hearing over 8 weeks. And they said, look, this, I know it is not all totally over now, but the good thing now, which we must all celebrate, is that Nigeria doesn't have to pay the 11 billion.
But the EFCC is opening a case against Mr. James Nolan, the British national at the center of the scam. What do you say to this?
Well, you see, in Nigeria, that's the point. You see, because the other thing you need to do is that, number one, if they want to open a case and it's not in Nigeria, they have to go through the extradition proceedings. Right. And another good thing is that, don't forget, the same EFCC, over the years, they've been telling us they are going to extradite Alison Madueke. That is almost 4 or 5 years up to now. Mrs. Madueke is still in United Kingdom. You see, before you extradite people to come and face criminal charges or whatever in Nigeria, there will be a lot of arguments that is going to be raised. One of them is this: do you even have a good prison system to start with? Let's look at it that way. Then does your judicial system move in a very punctilious manner? That is another question. And cases like this, you know, some of the criminal cases have been going on for 4 or 5 years. Right. And up to now, they can't even get the witnesses to enter the door. You know, so under the Human Rights Act, Mr. Lola can argue that, look, if I go back to that place to go and face trial, I'm going to face inhuman and degrading treatment, in which case the extradition may not go ahead.
Behind the scene, you were talking about how it is that there's still hearing going on with regards, that will be going on with regards to the case, and perhaps what Nigeria can push for at the end of the day.
Well, there are lots, because, look, the judge even made that clear in the judgment, where, you see, now he has set up that award aside, technically. And then, if you go by the Arbitration Act, he is supposed to decide what is the appropriate order to make. And if you go by Section 68 of that Act, it says, if there is shown to be serious irregularity, which is his finding, that has been established, affecting the tribunal, the proceeding or the award, the court may remit the award to the tribunal in whole or in part for reconsideration. Now, if he has come to the decision that this is a contract vitiated by fraud, what is he remitting it back to the tribunal to consider, to start with? That's one, but that's his prerogative. Yeah. That's two. It can remit the award to the tribunal in whole or in part. Oh, okay, I've read that. Yeah. Set the award aside in whole or in part. We know, as a matter of law, fraud vitiates everything. What that means is that whatever it is, it has no standing. So what are you remitting back? That's one. The last one, it can declare the award to be of no effect in whole or in part. So the next hearing is to decide that. And what he did is to give the lawyers the opportunity that, having studied the judgment, you can now come up with a draft order, the nature of the order you want me to make, if the both of you agree to settle it out of court. Or in the alternative, there will be a hearing. I will now decide under this section what order to make in these circumstances. But the grace for Nigeria is this. Number one, a lot of money has been spent on this case. If you look at the Nigeria used 2 KC, King Council, which is like.
But I didn't
son.
see a Nigerian in the list of council that represented.
Yeah, because
there were about 4 or 5.
It doesn't have to be.
Well, but then one would look out for
But it
its own.
doesn't mean they are not at the back trying to explain how things work. Because in that law firm, there will be a Nigerian lawyer, and there are, I think, about 2 or 3 of them working there. But they won't be visible, and you won't see their name. Right. But the name of the solicitor firm will be there. Okay. But so what the judge will decide whether to make the appropriate order under Section 68. Then there will be another issue about the cost. Nigeria must have spent almost $11 million on this case. And this money was spent, well, it's reasonable if you look at, this is a case that has been going
11 billion.
No. Look at how long the case has been going on. The first judgment was in 2010, and the whole thing started around January when the agreement was signed. So, and you look at the volume, you look at the personnel, you look at the expert, by the time you do the sum, the legal costs, and that firm, some of these King Council, they charge up to £1,000 an hour. And for any telephone call, even if you make a call to me as your solicitor, I still charge you it's 28 pounds that I charge for receiving your call. And then by the time you add the cost, you add the number of paper, you add the number of people
because it's your time.
Well, it's an interpretive proceeding. Absolutely. Somebody will have to pay. Yeah. So at the end of the day, but if Nigeria even spend 11 million to save 11 billion, that is money well spent, and nobody should criticize. But having said that, the judge will now decide. Nigeria is the winner as we speak. And normally, cost follow the event. The loser will pay the winner. That is one. Now, the judge will now decide at a point what cost order I should make. And there will be a lot of argument. There might be hearing for 3 days regarding the cost alone. Because the P&ID people will come and say, okay, what happened is this. They are not supposed to pay costs. Because, you see, there's something you call brutal and rough justice. Under the brutal and rough justice principle, now, police is your car, and it's a high-spec car that costs you almost $9,000. And you approach the court for an injunction that the police should return the car to you because you have the paper, this and that. And the judge made a return order that they should return the car back to you. Now, you got that. You got your car back, 9,000 what? Then you now go to the court and say, police should pay your cost because you pay your lawyer almost 70,000. You see, under the brutal and rough justice, the judge can tell you, no, your heart's desire is your car. And you've realized your heart's desire.
Right.
You got your car. That is what is important to you. The cost doesn't matter. So let cost lay wherever.
But not in this
belongs.
case.
But now, that is the argument. Nigeria's heart's desire is not to pay 11 billion, isn't it? And you got it. You got that, isn't it? So we got that. So the judge can turn around and say, well, if you are not paying the 11 billion, don't worry about the cost. Let everybody pay their cost.
Okay, but a quick question, Mr. Aino.
Yes.
Are you saying, because, some commentaries have it that there is still an option of appeal for P&ID. Are you saying now that as it is, this victory Nigeria has gotten at the London court is final?
No. I'm not saying that. And if you read the report, especially in Business Day, I think they got it wrong spectacularly. What the judge said, he didn't leave room for an appeal by adjourning the matter for another hearing. What he was saying is that what order I should make under the section which I've read to you now, that the matter should be listed so that I can hear argument to decide what is the appropriate order. It's not to appeal. But though that doesn't not mean they cannot appeal, but to lodge such an appeal, it has to be on a point of law. And now, what is the point of law? A judge heard the case over 8 weeks. He listened to evidence. There were a lot of ferocious cross-examination of the witnesses, and he has come to a decision. If you want to go and appeal, you need to show there's a compelling reason for the matter to appeal. And in this case, I doubt it. because the P&ID people, and on the issue of cost, what Nigeria should do, and appropriately, is that, you see, there is something behind the scene in this case. As of last week, if you listen to the Attorney General, the P&ID people were even exploring a settlement option. Because, you see, and they knew all along that certain things is not right about this case. They knew all along that the evidence obtained in America by the former Attorney General through his counsel shows payments being made to individuals at NNPC and the Ministry of Petroleum Resources. At that point, you should have taken a decision if you want to settle the case because you've seen the evidence. And there's one important thing they did, the P&ID people did, and that can lead to substantial court order against them. Along the line, they obtained privileged documents that belongs to Nigeria. It's like you, if you engage in a nasty divorce with your husband, and there is a letter from me as your counsel to you, advising you that you can take that money if you can get this and get that. That is a privileged communication between us. If by accident, that letter gets disclosed to the other side, the husband's lawyer, what they should do, immediately they realize this is a privileged document, they should return it back. Because they are not supposed to have access to it. And again, it helps them to know how you are running your case, okay? So it can cause a problem or know what is in your mind. Now, if you read this judgment, some people are facing disciplinary hearing because of their conduct. One of the King Counsel in UK, the judge has referred him to the Bar Council in UK because he obtained that privileged document that belongs to Nigerian government, and he did not even disclose it. And he was using that document to advance the P&ID case. And it has now transpired during the hearing that he had a conditional fee agreement with P&ID in which he will get 3.9 million if he wins the case. So you understand me? So because of that, there is a serious professional conduct against the solicitor and the Queen Counsel. So that is that. But Nigeria should try as much as possible because of the way the case was conducted by P&ID, because of the fact that they failed to engage with the evidence. Nigeria should now ask for an indemnity cost. And you see, when judges are making order regarding cost, it is either standard or indemnity. Standard in the sense that how long were you don't do it here much. When were you called to the bar? The judge will look at that. It will look at the complexity of the issues, whether it requires a senior lawyer to handle. Then it will look at how long it took and what have you. And whether some of the works done, they were very progressive of the case. It will now make a standard cost order that your rate, there's a guideline. My own rate is £280 an hour because they will look at where your office is as well to determine. And the judge will make a standard order. But where there has been a misconduct by the other party, who is supposed to pay costs, either for failing to engage in settlement, failing to disclose things properly, or doing it, the judge can now make an indemnity order, whereby the cost will double. That's what it means. The cost will double. So Nigeria can push and say, look, one, they obtained evidence improperly. When they received that evidence, they did not. They know Nigeria case all along has said that this agreement is a fraud it's a fraudulent agreement from the beginning. Despite that, they did not take steps. Despite obtaining all this evidence from America showing money being paid by P&ID to individual, they did not try to withdraw the case or settle the case. Because of that, Nigeria has lost a substantial amount of money. And also to individuals who put us in this mess. The government, you can decide one way or the other. And I think I listened to the Attorney General. He seems to be talking along that tune that we are going to pursue individuals. They can even pursue them for breach of duty, okay? Because you see, as a civil servant, transparency is the core principle. And I think it's about 7 principles of public service. They failed to embrace that. And the Nigerian civil service, President Tinubu, needs to look at things in the round, seriously. Look at what happened. Around one man, around Sanye or so, was the head of the civil service in Nigeria. What happened in the end? He was charged at a point to the Federal High Court. One woman took over from him, one Mrs. Giwa or something, I can't recall her name. She too, at the end, she was charged to court. The one there now, we hope it ends well. You see, so something is wrong somewhere.
Right.
So the court, explored that angle, the role of politicians, professionals, lawyers, civil servants especially. But the court also drew attention or asked states, countries in this regard, to now pay more attention to the arbitration process because it's an option, more convenient. It's supposed to be more convenient. It's supposed to be less rancorous.
Cost-effective.
Cost-effective too, and shorter as against the delays in court. But here we are seeing the court also acknowledging that it is becoming less reliable and prone to fraud.
Yes, I know. What the judge is saying is sending it to Parliament. The Parliament needs to look at the Arbitration Act and see whether it is actually delivering what it's supposed to do.
And you advocate that for the Nigerian system?
Well, definitely. Because you see, why the legal system in Nigeria doesn't really work, first of all, the judges are working under a very serious conditions, and the judges in Nigeria get irritated easily by little things. On the few occasions I've attended court, you see, sometimes because maybe the air conditioning is not working, or so, you see, the condition they work is very pathetic. If you have been abroad, you see, judges in the UK, this judge, I'm telling you now, we can even meet in Marks and Spencer. Knowing fully well, we just say, oh, hello, Mr. Aina. Then you say, hello, Judge. Everybody just move on. Do you understand me? There was a day I was in court and we were sitting down waiting for the judge. This gentleman now came in and now say, oh, good morning. I'm in one of the cases. Do you know when the judge is coming in? And he said, oh, I'm the judge. But I'm just reading the papers. In the next 10 minutes, I will be here. Very simple. Do you understand me? It's not, but if you dare do that here, oh, God.
You will even force the police ordinance before they will tell you to clear the way.
Let's not go there. Okay? Let's not go there. Okay? You see, if you have power, you have to be humble. There are certain things you can just look away. But we need to try and strengthen our judicial system so that, cases are dealt with speedily and in a cost-effective manner. And judges must exercise their case management power in a way. You see, there are women looking for maintenance and from their ex-husband. And those cases have been lingering on for years. Yes. There are people who lose their job, who are asking for compensation, and I'm on one at Ibadan. And we've been in that court since 2020. And I just realized that with this even come, when will the judgment come? And the judges, if you go to some of these courts, once you adopt your written address, I think some of them have 60 days to write their judgment. Then the judges have a backlog. So when you come to court, they will tell you, I'm not adopting any written address there today because they are pushing those cases backwards so that they can deal with the backlog, which is quite understandable. So, we need to try and strengthen our judicial system. We need to try as much as possible and make sure judges are well assisted. Look, if you go to the High Court in London, if you go to the Crown Court in London, you see these people sitting in front of the bench. Majority of them are barristers. They are legally qualified. But if you come here, you will see some of them with this head tie. You will just think they are coming from a funeral. And they are not even assisting the judge. You guys, because the legal clerk will have looked at the file, he will have given a summary. And some of these judges, because they are well experienced, some of them are practitioners over the years. Within 10 minutes, they can digest this and come up with a ruling. And this idea of delivering judgment because of election petition between Tinubu and Atiku, people are sitting in court for 8 hours. It's uncalled for. What you can do, write the summary, deliver the summary. Anybody who wants the full judgment, go and download it. Simple. I downloaded this yesterday. And within 1 hour, everything, it was there for everybody
But
to
we
read.
have been mouthing the matter of reforms in the judiciary for years. Attempts have been made. I recall that in 2020, when we had the COVID-19, there were times where they tried to, do some amendments to all of these activities, talking about having a virtual judgment and sittings and all of that. Even this year, we had one in Kano, NNPP, and we saw how people reacted to it. I'm wondering why it's difficult to have the kind of reforms we need in the judiciary.
It's going to be difficult because there are some people who have entrenched attitude. And because they have entrenched attitude, if you want to reform, bet me and you, they are going to resist it because they've been used to one particular way of life. So innovation is their enemy. They don't want to innovate because take for instance, most of the judges are used to writing with pen, writing everything with pen. If you go to the UK, the judge can just sit like this, asking questions because everything is being recorded. Also, there's a stenographer there who is typing everything speedily. So at the end of the day, if there's any issue, you can go back there. He doesn't have to take note. And he has studied the papers already. And even when I was a trainee solicitor, what they ask us is that once you get to court, ask the judge, my lord, have you had the opportunity of reading the paper? And some of them will tell you that, yes, I'm aware what it is. But if there's anything which is unclear, then he can ask you. So we need to try. Look, next week I'm going to have a hearing. Yesterday I went to buy the headphone, the camera in preparation. I don't need to be in the UK. And also judges must be available to citizens. Look, in UK, the court open 24 hours. I'm telling you, 365 days in a year. Forget what you go. As I'm here, if something happened to my client by 7 p.m., I can easily just sit at the corner and then phone the court, speak to the clerk. If he ask me what happened, he will say, okay, I'm going to get the judge to call you. Just stay on the phone. And it has happened before. These two ladies were about to be deported to Lithuania. And I told the immigration people that don't do it. Because I wrote you on Friday, you know I will not be in office on Sunday. You now reply on Sunday by fax and telling me they are on the way to the airport. Don't. And they won't agree. Then we called the judge. The judge said, look, Mr. Eno, I'm in Marks and Spencer shopping, but I'm going in my car now. I will call you. And they made the order right there and then.
Right.
You understand me? So we need to try and make sure we have a duty judge who will work. Things happen in the night than during the day. You understand me? So I'm telling you, if you have a paternity dispute with your man, he can come from Ghana to come and pick a child and said he's taking it to Ghana on a Sunday. And the airline will tell you that he's the father, they can't stop him.
Right.
So we need to have opportunity to call a judge who will make an order. So these are the things we need to look at in order to move forward.
We have to, it's been an interesting conversation, I must say, but we have to wrap things up now. We must thank you, UK-based solicitor and publisher, Village News, Olufemi Aina, for your time.
Thank you for all the program. Thank you.
Thank you.